You've heard the saying that elections have consequences. Well, that holds true for judges appointed to the bench. On this State of the Water, we'll discuss the impact of Senator Mitch McConnell on the federal judiciary during the Trump administration. This is State of the Water. I'm your host, Dr. Eric Claville, and we'll be right back after these messages. Welcome back to State of the Water. I'm your host, Dr. Eric Claville. We'd like to thank all of you for joining us on this beautiful Sunday afternoon here in Hampton Roads, wherever you're listening, whether it's the West Coast, the Midwest, the South, or the East Coast, or outside of the United States. We hope you're enjoying this beautiful Sunday afternoon. And again, we'd like to thank all of you for your support, because without you, we couldn't be who we are. But you're listening to WNSB Blazing Hot 91 during the 91 Days of Summer, State of the Water, which is an initiative of the Center for African American Public Policy here at Norfolk State University, home of the Spartan Nation. We have proud Spartans all across the world that support their alma mater with everything that what they can. They love their school, and they love it tremendously. So for those of you who have been joining us here on State of the Water during the summer, we've taken a closer look, and under what we call our Closer Look series, at various policies and acts and laws and public policy and that are really affecting our lives. And we like to call it a closer look because a lot of times you hear things on television, you hear it on your news outlet, and you're like, well, I heard it, I'll accept it as it is. But on this segment, we delve a little bit deeper to understand exactly why things are the way they are. Again, we want you to not just listen to what is said, but listen to how it's said, when it's said, and also what's not said, so that you can make a more well-informed decision for yourself. And that's what we do here on State of the Water. We don't tell you what to think, but we simply give you all the information so that you can make the decision for yourself. So on this A Closer Look series, we're taking a look at what we call Justice Senator Mitch McConnell and his impact on the federal judiciary. Now, again, we know that Senator Mitch McConnell is not a justice. He doesn't sit on the bench. But I use that tongue in cheek because of his indelible influence that he has upon the court, or has had, especially during the Trump administration. It's something that is tremendous. As a matter of fact, it's for some who are strategists, it's a work of art. But for others that see the other side of it, it's something that you should really, really stand up and take a look at and possibly fear. But we wanted to hear from you. So go to our website, our social media, at WNSBonline.org. That's at WNSBonline.org. Let us know your thoughts. Respond. You can go to whatever social media outlet that you like to use. We have it all here as well. Let us know your thoughts and continue to follow us on our social media. Follow us on our website, and you can never, ever lose track of what WNSB Blazing Hot 91 is doing here in your area. So let's take a look. We know that we have three branches of government. We have the executive branch, which is the President of the United States. We have the legislative branch, which, of course, is both houses of Congress, which, of course, is the House of Representatives and also the U.S. Senate. And we have the judiciary. Now, a lot of people pay attention to the executive branch because that is the President of the United States, right? I mean, he is the one that we see quite a bit doing press conferences. He's the leader of our free nation, of the free nation of the world. He's the most powerful man in the world position-wise, and he is the representative, or she is the representative of our nation. So, we do give deference, and rightly so, a lot of deference, to the President of the United States. In Congress, the legislative branch, we see where Congress has a lot of influence, a lot of power, because Congress is the only branch that can make laws. They're the only branch that can pass acts. They're on the branch that could pass, take bills and make them laws, statutes, and the like. So it's a very, very powerful branch of government, and really probably the most powerful branch of government as it relates to laws. But the judiciary is not a branch of law that we see a lot, right? It's not a branch of law that we hear a lot from, right? And rightly so, we shouldn't. Because, listen, as a lawyer, I loved going to court. I loved the trial aspect of it. I loved everything about it. But not too many people like going to court. Not too many people like going inside of those places. And I get it. I understand. It's very intimidating. And it's a place where one single decision can be made that can change the course of your life. The same is true for the federal judiciary. Now, with the federal judiciary, we look at that as being the U.S. Supreme Court. But there are other courts along with the federal judiciary. Now, of course, the U.S. Constitution made one Supreme Court. That is the United States Supreme Court. And it gave the power to Congress to make other courts as it deemed necessary. And by doing that, it gave Congress the ability to create additional federal courts to hear various cases. And that's where we have what's called the Federal Circuit. The Federal Circuit Court and the trial court, these are the courts in where you file your lawsuit in what we call district court. So every major city or area has a federal district court. That's where you initially file your lawsuit. And then from there, it goes up to the appellate court where you can appeal it. And there are various states that encompass that particular federal circuit court. For example, the Fifth Circuit Court of Appeals is made up of Texas, Louisiana, and Mississippi. And any action that is filed in either of those states of district court or trial court, they can appeal it to the seat of the appellate court, which is in New Orleans, Louisiana, and get a decision from there. And then the party that loses can appeal to the U.S. Supreme Court. Now, the U.S. Supreme Court does not have to hear that case, but you can appeal it, and you can what's called a writ, and you can file a writ, and they can consider to hear that case. Now, that's a very quick synopsis of how the federal court works. So why is the federal court so important? Why should we concentrate on the federal court? And why don't we concentrate on the federal court? The federal court itself is important because I believe it is the most important branch of our government. Why do I say that? The federal bench itself, or the federal court system, has the ability to say to Congress that created a law. Of course, someone has to bring a challenge to say, you know what? I know you got the power to create a law, but I think it's unconstitutional. Therefore, that law is null and void. In addition to that, they can say, well, I see what you did, but I think you should do this. That's what happened in the Miranda versus Arizona case. Before Miranda versus Arizona, the police departments did not have to read your rights. The Supreme Court stated what they should say. You have the right to remain silent. Anything you say can and will be used against you in the court of law. And so forth and so on. That is verbatim, copy and pasted, that was given to every police department, trained the officers, and now it's part of our everyday life. It wasn't a law, Marvin. It wasn't a law at all. It was a procedure. But the Supreme Court created that policy, and now it's used throughout. And the other very important aspect of the U.S. Supreme Court and all the federal courts is that they are appointed for life. They're appointed for life. Very interesting. That means now they can be impeached, they can die in office, and they can resign. But other than that, there's no other way that they can lose their jobs. That is absolutely powerful. So that's why we should be focused on the bench. But we don't, because a lot of times it's Marvin, looking at judges and what they do. Let's be honest, it could be a little boring. It's like watching paint dry. The law itself and the legal system is stoic. It actually takes a while to make it through the system. But once it makes it through the system and that ruling comes down, that becomes the law of the land. So once the judge gives their decision, their decision is read. Once that gavel slams down, case closed. You can know that is the final decision on that case. So the saying in the legal system is the Supreme Court is not final because they're right. They're right because they're final. So that is the reason why it's so important to concentrate on the court. Now, when we talk about politics, a lot of times we like those hot button issues. We like to look at people that are marching in the streets. We like to focus on things that are happening now. But Mitch McConnell, Senator Mitch McConnell, Republican out of Kentucky, he is the Senate Majority Leader. He had a more of a long-term look. He said, you know what? If I can't get the amount of representatives that we want in the House of Representatives or even in the Senate. Now, they control the Senate, but in the supermajority, then we can control the court. If we can't get our president elected the way that we want, we can control the court system. So Mitch McConnell put it on his mind years ago. He said that he was going to focus on reshaping the court system. Reshaping the court system. And by doing so, he worked tirelessly to get individuals appointed to the court who were of a certain type of legal ideology, a certain age group for longevity purposes, and finally, individuals that he could place strategically on various courts throughout the country, not just the U.S. Supreme Court, but throughout the country. Federal district courts, remember, we talked about it, federal appellate courts, and also the U.S. Supreme Court, and other what we call ancillary courts that are created. So let's take a look at what Mitch McConnell has done. Well, before we go there, let's break down what those three criteria mean and what they are. And then we'll look at what is the crowning achievement. And then in the second half hour, we'll look at the total impact from top to bottom. So Mitch McConnell, ideology that he wanted to have on the court were those who were conservative, very conservative. Now, why would he want that? Because he felt, and they felt, that the country was becoming leaning more toward the left, more toward the Democrats, or more toward what's called progressive policies. He felt that if the population is leaning more toward those policies, then what we will have to do, we have to create a backstop. That backstop, or that check and balance, again, which is why I believe the judiciary is the most powerful and most influential branch of government, is because they are the ultimate check and balance against all others, or the other two, the executive and the legislative. So if you can have a check and balance or a backstop against various policies that are not of the same ideology, then from there, we can have a chance to either create our policies or stop various policies from changing that currently exist, or change current policies that are there simply through the courts of making them unconstitutional. Now, with that being the case, the second criteria is that there had to be an age bracket, or age limit, because of the longevity purpose. If you take a look at the justices, and we'll do that in the second half hour, no one was appointed that was, I believe, over 60 years old. Over 60 years old. Now, I think it may be several here or there, but over 60 years, they had to be under 60. Because that gives you between 15 and 20 years, with good health and good living and the grace and mercy of God, 20 years on the bench. That's 20 years. And keep in point, the life of a judicial decision can be for decades, if not centuries. But in essence, it would have to take another challenge cycle to change whatever decision it is. So you're talking, Marvin, at least 25 years, ladies and gentlemen, at least 25 to 40 years for another challenge on the merits of a case once a case is decided to the U.S. Supreme Court and also through the federal courts. In other words, it's got to work its way through the cycle. It's got to work its way through the cycle. Case in point, I mean, we could take a look at challenges to various voting laws. The 1965 Voting Rights Act that was passed in 1965 had pre-clearance as part of it under Section 5, 4B. And under that, states had to present any changes to their voting patterns or voting laws to the U.S. Department of Justice to get it pre-cleared, to determine if it was constitutional or not. Well, 1965, that provision was challenged in 2015 under Shelby County versus Holder. And guess what? It was changed. The Supreme Court said no longer do we need pre-clearance. No longer do we need that particular provision because population or the impact of non-whites or what's called minorities is at a high rate, higher than it's ever been. So there's no way we need this. Well, the court was wrong. We talked about that in our voting rights series a couple of series back. So you can go to YouTube and our online at wnsbonline.org and listen to it. But if you take a look at that, if you take a look, how many years was that? You're talking 50 years, about 50 years that it took to challenge that and change it through the U.S. Supreme Court. That's how long the impact of the Voting Rights Act decision was on the voting patterns in the U.S. So if one decision is made and then it takes 50 years to change it in the other direction, that's just one. And the Supreme Court hears about 100 some odd cases a year. Think about it. So multiply that times 20. And then every decision made 50 years from that to challenge it on average. That's huge. That is major. So that's why the age requirement is so important. You're listening to WNSB Blazing Hot 91 during the 91 hot days of summer. You're listening to State of the Water. I'm your host, Dr. Eric Claville, an initiative of the Center for African American Public Policy here at Norfolk State University, home of the Spartan Nation. We want to know your thoughts on the impact of Senator Mitch McConnell and the Republicans on the federal judiciary. We're talking about it here right now. We're outlining, and we went through what the federal court is, why it's important, the criteria of Senator Mitch McConnell, and what his crowning jewel is. And in the second half hour, we're going to take a look at the impact from the top down. But let us know what you think. Go to our social media at wnsbonline.org. That's at wnsbonline.org. And let us know your thoughts. So the federal judiciary, as I said before, is the most important, I think, and impactful area or branch of government because it's the ultimate check and balance. We see now that Senator Mitch McConnell put his eyesight. He locked in on challenging the court itself and ensuring that the court becomes that of a conservative ideology to help to turn the tide back, to help to understand the side of the conservatives and a push against the progressive or the left or the liberals, however you want to frame it. So the third criteria, not only was it an ideology, but also the actual age requirement itself, but also strategic placement across the country. We see where the most liberal circuit court in the United States, which was in California on the East Coast, actually was changed because of the appointments made to that court. So what was the most liberal now is the most moderate out there. That is amazing because we never thought that that particular circuit would actually change because that circuit targeted a lot of policies being challenged that of conservative ideology. In addition to that, various district courts, justices that sat on district court and justices that sat on appellate courts that were older were actually stepped down during the Trump administration in order to have their successor appointed. Now, that's very interesting because we're going to take a look at the impact of not stepping down soon enough for the Democrats and how that impacted them. So they were able to convince, or I would not say convince, but give a solid reasoning why it was important for them to retire at that point in time, as opposed to dying in office or resigning or being replaced by a president who was not, or Congress or Senate that was not of their political persuasion, meaning Republican or conservative, and being replaced with somebody that would actually be opposite of that. So they were able to convince those individuals to step down. Now, let me give you an example of two instances where they didn't do that on the Democratic side, the liberal side, and it impacted them tremendously. Justice Thurgood Marshall tried to hold on. He could have stepped down prior to the president that actually ended up replacing him. But he tried to hold on. But he simply could not. And by not being able to hold on, becoming sick, and actually ended up passing away shortly afterwards. His replacement was the second African-American Supreme Court justice, which was Clarence Thomas. And that impact on the U.S. Supreme Court made a huge difference as it relates to policy. And let's take a look at the recent time period of Justice Ginsburg. Justice Ginsburg herself became very ill. We had two terms of President Obama. And in those terms of President Obama, she could have stepped down, but she ended up not doing it. Unfortunately, she had cancer for a very long time and ended up succumbing to it. And under that, the Republican Party was able to replace her again with another conservative justice. That is the impact of waiting too late to step down. That's the impact that Senator McConnell and the Republicans wanted to avoid. That is, again, one of the major criteria that Senator Mitch McConnell was able to create and get accomplished in helping to reshape the federal judiciary. So let's take a look now at Senator McConnell's crowning jewel. Again, the impact of not stepping down at the right time and too late has a monumental effect on the future of who your replacement is. So with that being the case, Mitch McConnell himself helped to reshape the federal judiciary from the district court, the appellate court, and the U.S. Supreme Court. His crowning achievement had to be the U.S. Supreme Court because now the U.S. Supreme Court has a 6-3 majority. 6-3 majority on the conservative side. That is huge. That is actually monumental. And that was only able to happen because of just 3 justices appointed to the court. Justice Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Those 3 individuals in one presidency, they were able to push through and get approved these 3 Supreme Court nominees. That is, first of all, just for someone that, follows the bench, follows politics and the like, this is phenomenal. I mean, this is something that you don't see. This is absolutely amazing what they were able to do. Again, I'm looking at it as a strategist, right? So let's take a look at those three criteria. So we already know that one criteria is to replace and strategically receive an advantage of a conservative ideology in every key court across the country. So we know that that is satisfied here, that criteria. So we're not going to go over that. But we're going to look at the two other, the conservative ideology and the age. Neil Gorsuch, at the time that he was appointed, was 53 years old. That is absolutely huge. Absolutely huge. Currently 53 years old. With that, now, if you take a look at the under 60 criteria, I mean, if all holds well, God gives him good health, he'll serve on the bench over 20 years. We're talking at least 25 years, maybe 30 years at age 83. He can do it. I mean, 80 is the new 60 now, maybe 65? It could be done. So you're talking someone who has a minimum of 20, realistically 25, maybe 30 years on the bench of making decisions. And yes, he is a conservative. And he actually was preceded by Anton Scalia, who is probably at that time the most conservative justice on the Supreme Court. Then, of course, we have Brett Kavanaugh. Brett Kavanaugh, of course, we know a lot of the controversy behind his confirmation hearing, very similar to Justice Clarence Thomas. But ultimately, he made it to the bench. At age 56, again, 20, minimum 20, 25, or 30 years on the bench. Again, absolutely, just a monumental turn of events. And he replaced Anthony Kennedy. Anthony Kennedy, probably the most important Supreme Court vote in the last at least 10, 15 years, because he was the moderate. He was a swing vote. So now a conservative, ideology-wise, is now the swing vote on the U.S. Supreme Court. And finally, Amy Coney Barrett, 49 years old. 49 years old. Justice Gorsuch from Colorado, Kavanaugh from Maryland, and Amy Coney Barrett, 49. She is from Louisiana. Again, all three states, for the most part, with fairly conservative circuits, replaced now, or moderate circuits, conservative and moderate, now replace one conservative, one swing, and one liberal justice on the U.S. Supreme Court. And there's a 6-3 vote block. Absolutely amazing. So look, in the second half hour, we're going to take a look at the impact of Senator McConnell's strategy on the court and how it will affect us for years to come. You're listening to Stay in the Water. I'm your host, Dr. Eric Claville. Stay tuned as we come back and take a look at Mitch McConnell's impact on the federal judiciary. We'll be back after these commercial breaks. Welcome back. You're listening to Stay in the Water. I'm your host, Dr. Eric Claville. We want to thank you again for joining us on this beautiful Sunday afternoon. We know that you could be doing a lot of other things, but we thank you for giving us a little portion of your Sunday to tune in and listen to us here at WNSB Blazing Hot 91, doing the 91 hot days of summer. You're listening to us here on the campus of Norfolk State University, home of the Spartan Nation, a place where we have proud Spartans all across the country, all across the world, that love their alma mater and support us truly. And also our phenomenal leader, our president, Dr. Adams Gasting, who is here leading us on our new mission and charge to continue to be the towering force here in not just the Commonwealth or the country, but in the world. For those of you that have been joining us here on the first half of the show, we've talked about Justice Senator Mitch McConnell and his impact on the federal judiciary. So again, you know that we or this is part of our summer A Closer Look series, where we take a look at various issues and laws and public policy that we hear every day, but we don't really delve into it. We're busy living our lives, trying to do the very best that we can. But on this series, we take a look at exactly what's in there. What are they talking about? And as I like to do, and as I do on the show, and I lecture in my classes, I don't teach you what to think, but we simply give you all the information so that you can make a more well-informed decision for yourself. So, with that being the case, what we've delved into in this A Closer Look series, this episode, is the impact of Senator Mitch McConnell on the federal judiciary. In the first half, we actually looked at the various branches of law, why I feel the federal judiciary is so important. We actually broke down the federal judiciary and the importance of it being the ultimate check and balance against the executive branch and the legislative, or the president and Congress, and also the fact that they are appointed for life. There's once you become confirmed on the federal court, you're there. And the other aspect about it, I didn't mention this in the first half hour, but if you're a federal judge, guess what? You didn't run for office. You were appointed, you were nominated and appointed. Nominated, confirmed, and appointed. That's it. You simply ran on your record. And of course, there's politicking that goes on, trust me, behind the scenes and the like. But it's a very quiet, close. Of course, it's open to the public. But when I say close, the negotiations that take place and the discussion that take place, we really don't hear about it. Like in politics, you hear, what we call the political machine that slings mud at this candidate and that candidate. But the federal judiciary, you don't hear that. You don't run for office. You're nominated, confirmed, and then appointed. You're there for life, and you simply run on your appointed and consider on your record. But keep in mind, politics does play a major part in this. So why the judiciary? Why did Mitch McConnell himself really lock his eyes on there? Well, Mitch McConnell, at a very young time, he actually worked in the Senate office where he worked under and saw Republican nominees of presidents rejected, more specifically under Richard Nixon. And he saw how important it is in order to win what's called the game of judicial politics. And he really bit his teeth during that time period when he was fairly young. And he was exposed to this mechanism when he worked for Marlowe Cook. He was a U.S. Senator from Kentucky. And who sat on, at that time, the Senate Judiciary Committee. And as a staffer, he saw, again, two of Richard Nixon's Supreme Court nominees not make it through, rejected. So he understood the importance of how to play this game. He understood the importance of judicial nominations. He understood the importance of both Supreme Court nominations and federal lower court nominations. And you can see this. This is part of the Alec McGillis, who is the author of The Cynic, The Political Education of Mitch McConnell, as told on Frontline in 2019. You can read his book, or you can go to the Frontline Investigative Series and see more of that. But that's where he really bit his teeth, Marvin, in this game, the game of judicial politics. I like that, right? Because ultimately, like I said, justices, they run on their record, but they're appointed on their nominated, and they're nominated, confirmed, and appointed, but they don't really spend money on campaigns and the like. But it is politics. It's politics all behind it. So he stated, Mitch McConnell, again, going back to this Frontline documentary investigative series, he saw during a time period where, at that time, Harry Reid, who was the Senate Majority Leader, he basically changed the rules, eliminated filibusters for federal judicial and executive branch nominees, with the exception of the Supreme Court nominees. And this is when Mitch McConnell, again, of course, the Republican wanted to block some of the nominees and so forth. Well, Mitch McConnell made this statement. He told the Democrats, he said, "You'll regret this, and you may regret it sooner than you think. Those are his words that he said. You will regret this, and you may regret it a lot sooner than you think. So, again, according to this investigative piece on Frontline, when the Republicans took control of the Senate in 2015, confirmation of Obama judicial nominees, they slowed to a crawl. And that's true. As a matter of fact, the biggest story of an Obama nominee to the U.S. Supreme Court that stalled was Merrick Garland, who's currently the Attorney General for the United States, Department of Justice. So Merrick Garland was a moderate. He was a moderate Supreme Court justice. I personally think that Obama should have nominated the first African-American Supreme Court nominee. I thought that if he would have done that, he didn't have any other elections to run. He could have nominated African-American female from one of the circuit courts or the state Supreme Courts. And for the Republicans to push back on an African-American female with that type of pedigree would have been political suicide for the most part. But it also would have given more, I believe, it would have bolstered the opportunity to appoint a Democrat to the Supreme Court. But they didn't do that. And you would say, why would President Obama not want to do that? Well, President Obama himself believed that the courts were not that important. He believed that more good can be done through the legislative side as opposed to the judicial. So it really wasn't that important to it. Plus, he felt that, hey, if I bring in a moderate, he's more likely to get over the hump and get nominated. Well, when you're playing politics and the game of judicial politics, Mitch McConnell knew from the Nixon days, you got to play hard. And that's exactly what he did. They didn't even give Merrick Garland a courtesy sit down because usually justices go from office to office talking with, senators and the like. Just say, hey, having a customary tea or cup of coffee and having a conversation. Basically, I'm out of the courtroom. I'm just a gentleman to a gentleman or a gentleman to a lady, and we're talking. They didn't even give that. So what happened was Mitch McConnell believed that when Trump got in office, he would be able to appoint whoever he did and change the court. So when Trump won in 2016, in that election, he employed the nuclear option when the Senate Republicans blocked filibusters for Supreme Court nominees, stopping these attempts from Democrats to block Neil Gorsuch's confirmation in 2019. Also in 2019, Senate voted to cut debate from 30 hours to 2 hours only for lower court nominees. And this change would apply to judicial nominees for district courts, but not Court of Appeals or Supreme Court, according to this investigative documentary. So with this is what they were able to do. Now, again, let's take a look at the amount of justices appointed to the federal bench. On the U.S. Supreme Court, 3 U.S. Supreme Court justices were appointed. They were actually nominated by the conservative think tanks through the Senate. They were confirmed and they were appointed. Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett. That gives the conservative side a 6-3. A 6-3 block on or balance on the U.S. Supreme Court. The U.S. Courts of Appeal, there were a total of 54 justices appointed to this particular bench. The Ninth Circuit was almost remade. The Ninth Circuit at that time, before that time, being the most liberal circuit, was almost remade. Thought we'll never see it. But again, Mitch McConnell understood the importance of reshaping at every level. So the U.S. Supreme Court is reshaped. The various federal circuits of appeal are reshaped, including the Ninth Circuit. And then under the U.S. District Courts, which is the trial court of first instance, that's where everybody files their first lawsuit for any federal issue under what we call law of fact or question. Of course, USC 1331, 1332. this is where you filed those actions. 174. 174. Again, in 4 years, 174 district court justices were appointed. That's crazy. That is actually in 4 years. That's huge. And then finally, on the other courts, and keep in mind, you not just have the U.S. Supreme Court, the Court of Appeals, or the District Court, but you also what we call other ancillary courts. So you have the United States Court of International Trade. You have 3 justices that were appointed there. United States Court of Federal Claims, which is a specialty court of Article 1. 10 justices were appointed. U.S. Tax Court, 7 justices were appointed. United States Courts of Appeal for Federal Claims, 6 justices were appointed. On the U.S. Court Appeals for Armed Forces is 2. The Court of Military Commission Review, 1. And Territorial Courts, which is an Article 4 court, you have appointed 1. And also, there's an alum of my law school who was appointed to the federal district court there. So this is something that Senator McConnell, I call him Justice McConnell for this, tongue in cheek, said we've got to reshape it. And that's what they were able to do. That's what they were able to do, reshape it. So how does this stand against other presidents? And what did they actually, and what's the impact of this? So under this particular president, President Trump, Senator McConnell, he was able to push a large number of federal court of appeal justices in only 4 years. Now, how does this stand? Overall, in a single term, he appointed 226. 226. Now, according to the Pew Research Center, in one term, Trump appointed 226 as nominated and confirmed through Senator McConnell's court. I call it court, but again, through the Senate. Under 2-term presidents, Obama appointed 320, Bush 322, and Bill Clinton 367. But he was able to do this, a total, in only 1 year. It took 2 years for the other presidents to appoint, 100 more or less than what Trump appointed. So just think if Trump would have won re-election, then the court would have been totally changed. That's absolutely amazing. Again, now let's take a look at demographics. How did Senator McConnell and the conservative think tanks, what did they think about demographics and gender when they're appointing justices? Well, you would think that we're more of a melting pot in America. You would think we have more non-white males who are now going to law school, now partners in law firms, now serving on the bench, now doing various things and appointed to offices. You would think that it would be more of a diverse set of federal judges, right? Nope. The appointment, the nominations and confirmation of just judges, federal judges appointed by President Trump that came through Mitch McConnell and the Senate, they appointed a smaller share of non-white federal judges than any other recent president. In other words, 1 in 6 judges appointed by Trump, or 16%, are either black, Hispanic, Asian, or another race or ethnicity. You had to lump in everybody except white to get 16%, 1 in 6. So of that number, that 226, you had to lump in everyone else, black, Hispanic, Asian, another race or ethnicity, just to get a little bit more than 15%, right at 16%. So now that's, of course, worse than other Republicans, but George Bush was 18%. Obama, of course, was 36. Clinton was 25. Jimmy Carter was 22. So now the federal bench is not only reshaped with the ideology, conservative ideology, across the country in every single level of federal courts, is not only reshaped under the age limit of under 60 across every court, federal court in the United States, but now is also shaped with one major demographics that's declining in America, and that's white males. Again, the ultimate check and balance in the game of judicial politics. This was a strategy, not just thought of from the beginning, but for years. That's the power of the court. And we're going to see the power of the court with a lot of these decisions coming up. We're going to see the real power of the court and how they're able to turn the tide and a lot of laws that actually help to create a more equitable and equal society. So elections, yes, they do have consequences. Now, as it relates to ethnicity, let's take a look at gender. With women judges, Democratic presidents have generally, according to Pew Research, been more likely than Republican or GOP to appoint racial or ethnic minorities on the bench. With that, keep in mind that there has been no black woman to ever serve on the U.S. Supreme Court. We've had white, we've had Hispanic, but no black. And also we've had Jewish as well. But no black woman has ever served or been appointed to the U.S. Supreme Court. Now, should a vacancy arise, Joe Biden has stated that he would appoint a black woman. But to this day, no black woman has ever served. So we'll see. Again, elections have consequences. We have to ensure that we hold individuals to their campaign promises and see what happens. But I want to break this down just a little bit more here under demographics, because this is very important. This is very important. So let's look at the numbers. Out of 226 judges appointed to the court, nominated to be appointed to the court by Senator Mitch McConnell in the Senate, 189 were white. Only 9 were black. 9. Only 9 were Hispanic. 13 were Asian and 6 were other. For a total of 37 non-white. 189. Now, under under Obama, you had 58 black judges appointed. That's huge. Under George Bush, you had 24. But under Clinton, you had slightly more. You had 61. 61 black judges appointed. You only had fewer than, under one president, only had fewer than Trump, and that was Reagan. He only had 7 black judges or justices appointed to the bench. 335 were white under Ronald Reagan, with 14 being Hispanic, 2 being Asian, 0 other, and 23 total non-white. So when you start taking a look at it and you go into court and you're taking a look at these decisions that are made, this is the face of these decisions that are being made. And of course, again, the law is blind. We know this. There are words on the paper, right? But the people that are applying the law, the people that are arguing the law, the people that are looking at these words on the paper and giving their explanation based upon their experiences, based on their ideology, based upon their belief, that's the power of these decisions. And that's how it's going to be interpreted. You're listening to WNSB Blazing Hot 91 during the 91 hot days of summer. This is Stay the Water. I'm your host, Dr. Eric Claville. We thank you again for joining us as we take a look at a closer look series, the impact of Mitch McConnell and on the federal judiciary. You know, why was the federal judiciary, the court, so important to Senator McConnell? Why did he take extreme measures to appoint the individuals he appointed? And what's the importance of these, of the impact of these appointees in the future? Let us know your thoughts. Go to our social media at WNSBonline.org. That's at WNSBonline.org. Go to our social media. Give us your thoughts on what you think the impact is and what should the other side, the Democrats, do to counter this. And why is the attention not focused on the courts on the other side? And what do you believe will be the outcome moving forward? So let's take a look at, finally, the overall impact of these decisions. What do we think they would have on various rights? So let's go back a little bit to what I believe are some of the most important time period as it relates to, we call them civil rights, but really human rights legislation enacted across the country. So, unfortunately, after the assassination of President Kennedy, assassination of President Kennedy. President Clinton was not assassinated. But in the 60s, we had the unfortunate assassination of President John F. Kennedy, who had a vision for the country to really shape it in a different vein, a way that's more equitable and equal. He wasn't able to live out those promises. But Lyndon Johnson said, I'm going to make sure that his dream and the vision is accomplished. So with that, he signed some of the most sweeping federal legislation out there. And a lot of this legislation, believe it or not, was really an attempt to resurrect a lot of the Civil rights legislation. A lot of these acts were already passed in the 1800s, 1865, 1866, 67, 68, 1870, and the like. But the problem was it didn't have the enforcement of the federal law. It didn't have the enforcement of penalty of individuals that abridged the rights of people, the human rights. Again, we call it civil rights, but I simply call it human rights because it's human just to do the right thing, to help people, right? So he passed this sweeping legislation. Of course, we know that I believe the most important part was, of course, the 1964 Civil Rights Act. Also, secondly, the Voting Rights Act, 1965. And then, of course, many other acts as it relates to housing, higher education, and the like. So with that, the power of the vote is the one that is under continuous attack. Now, there are other provisions under the other civil rights legislation that I believe will be challenged, okay, in the future. Hands down. If we take a look, again, at history, we take a look at what's being done or has been done, I believe that simply history is something that to be repeated if we don't learn from it. And we find that that's been the case quite a bit. But I want to focus on civil rights, and then finally, I want to focus on civil and voting rights. Let's use voting rights first. We found that the impact of the Voting Rights Act helped to eliminate and make it a penalty for anyone to abridge anyone's right to vote. So it eliminated and made unconstitutional all of those egregious provisions to stop African Americans from voting, such as literacy tests, grandfather clause, and the like. Again, we explored a lot of this in our last two series on voting rights. You can go back and listen to it on our YouTube channel or on our website at WNSBonline.org. And it made those unconstitutional. It brought in enforcement for anyone trying to do it, intimidation at the polls, and the like. Because of that, we have more individuals, African Americans elected to office, and individuals are now able to vote their conscience. They're able to vote and say, hey, I want this person elected. I want this person represented. I want this policy. I want this law. I want this regulation. I want these various provisions to be governed under. We have many individuals on our school boards and in our municipalities, city council, state legislature, U.S. Congress, and of course, the highest office of the land, the president, elected who are African American and also women. Keep in mind, women got the right to vote under the 19th Amendment. So we celebrated 100 years of women's suffrage last year. So with that, various provisions to keep these states from discriminating against African Americans and others from voting was actually eliminated after 50 years in Shelby County versus Holder, which now means that anybody, any state or federal covered state, formerly federally covered state that discriminated against African Americans and non-whites, now can pass whatever law they want. Whatever law they want that they believe will help to get their side to win. And that's what politics is about. It's winning the game. And you win the game by simply creating the rules that gives you the advantage to win the game. That's what politics is. And that's the game that's being played. So that was challenged. That was challenged in the courts, and we see that that provision is gone. The impact was 50 years, where now we were able to have these provisions, this protection under the law. But now that's over with. Now, other challenges that are coming to the court, such as in Arizona, where various provisions allowing the collecting of ballots and also your vote counting if you vote out in the wrong district. Let's just say you move and you vote in the wrong district, well, your vote won't count at all, even though you voted in the wrong district, but you still voted. This is basically what Justice Kagan said, the final assault, almost the final assault of dismantling the Voting Rights Act. So we see that these provisions that are in our various laws that are helping us to maintain an equitable society are being challenged, and the rulings will have an impact across our world and across our country for decades to come. So elections have consequences. Again, we want you to go back and take a look at a lot of this research on Pew Research and also Frontline Investigative documentary about the impact of Mitch McConnell and on the federal judiciary. Again, elections have consequences. So make sure you go out and vote often. Thank you again for joining us here on State of the Water. I'm your host, Dr. Eric Claville. We want you to continue to join us this summer for our Closer Look series. We'll see you next week.